The rule of law demands that such rules be clear and constant, knowable, and predictably applied. Joerg Knipprath. The principle of establishing justice through the rule of law is a means of guarding against gradual erosion of law and order into chaos. To break down America's system of self-governing, it guards against eventually ushering in tyranny to control the people, rather than protect liberty by protecting the rule of law. Quote, "You seem to consider judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one that would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and the privileges of their corps. Their power, the more dangerous, as they are in office for life, and not responsible, as the other functionaries are, to the elective control. The Constitution has erected no such single tribunal, knowing that, to whatever hands confided, with the corruptions of time and party, its members would become despots." Thomas Jefferson, in a letter to William Charles Jarvis, Monticello, September 28, 1820. The quote passage by Thomas Jefferson addresses an issue that has been a repeated topic of controversy since the United States Constitution was proposed to the state conventions, namely the role of the unelected federal courts in a system grounded in popular consent and self-government. Courts are supposed to apply the law prescribed by the people's representatives, but not be swayed by popular opinion in particular cases. In ordinary criminal cases or civil suits, that is indisputable. In cases of constitutional law and judicial review of the constitutionality of the acts of elected officials, the matter becomes more ambiguous. Such cases are inherently political in that they present a challenge to self-government and call into question the particular competence of judges to resolve them. True, some topics, such as foreign affairs, are more political than others, such as specific guarantees of individual rights. But as has been noted by various writers, each time a court strikes down a law, that action can be seen as a blow against self-government. When the Supreme Court decides a constitutional law case, they affect the entire country, not just the specific litigants. Moreover, those litigants often do not represent the opinions of a popular majority on the issue. To be consistent with the fundamental Republican principle of majority rule, should unelected courts be making such decisions at all then? Abraham Lincoln made the point succinctly in his first inaugural address when he pledged non-interference with a specific decision in the Dred Scott case about Scott's inability to sue for his freedom, but also declared, quote, "At the same time, the candid citizens must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed on decisions of the Supreme Court, the instant they are made, in ordinary litigation between parties and personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government to the hands of that eminent tribunal." End quote. If the federal courts are to have the power of constitutional review, is the argument for judicial independence as strong as in an ordinary criminal case? Republican government was premised on the idea that the people, or some portion thereof, deemed sufficiently qualified, would decide the important public matters. Unlike in a democracy, they would do so through representatives selected by them directly, or, in the original design for the Senate and the President, more circuitously. Should a 5-4 majority of the unelected Supreme Court effectively have the final word, or should a majority of the people's representatives have the power to override the court's holding on the matter? This is a particular problem in that the Supreme Court is selected from a very small class of society, an elite whose cultural and political values differ sharply from those of the American people as a whole. Should federal judges be elected rather than appointed? Indeed, considering the classic Republican principle that the greater the power, the shorter the term in office in order to avoid oligarchic control, should federal judges serve very short terms before returning to their ordinary stations in life? All these questions were raised by various anti-federalist writers during the debate over the adoption of the Constitution. The potential life tenure of federal judges was a glaring red flag for critics of the proposed charter. Technically, the tenure exists during good behavior, but that ambiguous concept itself was tied to the practice of impeachment. As impeachment increasingly came to be seen as a limited tool requiring something more than political disagreement or general unpopularity, the Constitution expressly provided specific and quite restricted grounds for removal of officers by that method. But anti-federalist attacks on the federal courts were not limited to the issue of life tenure. Although the Constitution is silent on the matter, the opponents soon focused on the perceived ability of the Supreme Court to sit in judgment of the constitutionality of the actions of the people's representative in Congress and the state legislatures. A very sophisticated attack on the Supreme Court appeared in 1787 and 1788 in various essays of Brutus, one of the two pen names generally attributed to the New York judge and eventual state chief justice Robert Yates. Yates had been selected as one of New York's 3 delegates to the Philadelphia Convention, but, along with Judge John Lansing Jr., had left that assembly early because he objected to the nationalizing tendencies he saw in the emerging draft. His essays were very influential in the debates in the critical New York ratifying convention. In essay number 11, published January 11, 1788, Brutus observed that Article 3, Section 2 of the Constitution vests the power to determine all questions that may arise under the Constitution. He questioned whether that power would be used for the general good. Brutus worried that the federal courts would interpret the Constitution's often ambiguous language broadly in favor of the general government to the eventual, quote, subversion of the legislature, executive, and judicial powers of the individual states, end quote. Applying the history of the English Court of Exchequer, he charged that the courts would extend their jurisdiction and influence well beyond that understood at their creation. In essay number 15, published March 20th, 1788, Brutus again addressed the danger to the people's liberty and to the existence of the state governments from the lack of any control over the constitutional decisions of the Supreme Court. The solution would have been to make the Supreme Court decisions subject to review by the legislature, much as English court decisions often were subject to review by the House of Lords. The effect those and other critical essays Yates wrote about the proposed federal judiciary had on New Yorkers finally prompted Alexander Hamilton to write a response, published on May 28, 1788, just ahead of the meeting of the New York Ratifying Convention on June 17th. Essay number 78 of the Federalist is among the longest of the papers and the one most frequently cited by the Supreme Court. Hamilton agreed with Yates that the federal courts would interpret the Constitution, because the Constitution being law, it, quote, is the proper and peculiar province, end quote, of them to do so. Judicial review was to be conservative in the sense of protecting the received constitutional order from the excesses of momentary popular passions, as well as from, quote, the cabals of the representative body, end quote. That, too, is consistent with the rule of law. It is also consistent with the Republican self-government. as it merely seeks to slow down the rush to action by allowing for further reflection and the triumph of reason. What is not consistent with Republican self-government and legitimate Hamiltonian judicial review is when the judiciary assumes the role of constitutional innovator. For example, when the Supreme Court overturns long-settled laws that affect basic institutions of society or traditional social relations, it is not guarding the liberty of individuals or political minorities from temporary majoritarian passion. It is, in effect, amending the Constitution by a simple majority vote of one branch of government composed of a few members enjoying life tenure, the branch that has no accountability to the public and is drawn from a very small elite. That is consistent with neither the stability and predictability associated with the rule of law, nor Republican self-government. In taking such actions, the court assumes the role of a constitutional convention. Relying on the postulate of popular sovereignty, Hamilton, James Madison, and other supporters of the Constitution emphasized as a first principle of the people's right to change their Constitution anytime and for any reason. Such innovations should not be undertaken lightly, and at least as codified in Article 5 of the Constitution, require a difficult supermajoritarian process involving multiple governmental bodies, radically different from judicial constitutional amendment by a 5-4 vote. Joerg W. Knipprath is an expert on constitutional law and member of the Southwestern Law School faculty, and he is also a Constituting America Fellow. I am Janine Turner, founder of Constituting America. I and Kathy Gillespie, Constituting America's CEO, thank you for joining us for our 13th annual 90-day study. Our annual studies are entitled 90 plus 90 equals 180. History holds the key to the future, because history does hold the key to the future, or as Shakespeare said, the past is prologue. Join us tomorrow, right back here, same bat channel, same bat time, for those of you who are as old as I and watched Batman, the TV show. Don't forget to check out our essays on American exceptionalism. It's our study from last year. If you go to the constitutingamerica.org and scroll down, you'll see the studies, and you'll see a little red button that says American Exceptionalism Study. Really good, so that we have 90 days of 90 tools in our toolbox so that we can have a really good civil civic conversation about why America is exceptional. Have a great day. We thank Amanda Hughes for championing these wonderful studies, and for Bobby Rodriguez for editing these wonderful essays and sending them out there into the universe. Have a wonderful day.